So I'm just checking my mic, just checking if everyone can hear me. So if you can just maybe comment on the chat box if you're able to hear me. Yeah. Okay. Thanks, Dr. Malind. Thank you. Just okay. All right, everyone. Thank you for joining today. So hopefully we hoping for no any interruption. And for those who experienced it yesterday on our session, we really apologize. And as we have mentioned, we will let you know as soon as the webinar has been rescheduled. So you should be receiving a notification. Sorry for that. So welcome to our session today. Before we get into it, I just want to let everyone know that you can actually disable all the notifications. So if you can just go on the settings and ensure that you untick all the boxes or uncheck them so that you don't experience any sort of interruption when you're trying to watch the session. Yes, so welcome to our session. My name is Perry Digota. I am based in the South African office. So today's topic is intellectual property IP for engineers. This will be presented by Dr. Arti, who is also EIT lecturer and course coordinator. And then we will also be sharing a link to get your certificate of attendance. And then also upon completion of this session, just after, like in 2 days, you should be receiving a copy of the slide and together with the recording of this session. So yeah, I'm gonna now leave it to Dr. Arti.
Thank you very much, Barry. Just quick check on audio. Can you all hear me?
Yes.
All right, great. Thank you and welcome everyone. My name is Arti and as Barry mentioned, I'm a lecturer here at EIT and I'm also course coordinator. I've been in academia for almost 2 decades now and have a lot of experience teaching mechanical engineering units at various levels, bachelor's, master's, and I'm also teaching a unit at Doctorate of Engineering level. So that's what sparked my interest in intellectual property because that unit was slightly different and that's why it was slightly challenging as well. And that gave me a lot of in-depth knowledge and I'm still curious to keep exploring more and more. So let's move on without any further ado. This is what we are going to do today. We'll start with basic introduction and we'll set up the stage for learning more about intellectual properties. We will cover a few intellectual property types and then we will also touch base a bit on our ethics considerations in intellectual property. And in the last slide, I will share some intellectual property resources. So before I begin, let me just make it clear that most of the stuff I'm going to cover today is from Australia. Legal framework, which is prevalent here in Australia, it's based on those things. But saying that, it's not much different in various countries. And this is my last slide where I will cover various resources, will also give you a lot more guidance on whom to contact in your particular country. Saying that basics remains the same everywhere, doesn't matter whatever corner of the world you are in. By the way, I'm based in Perth, so that's where I am, and that's why I said I'll start. I will cover it from the Australian aspect. All right, let's begin, everyone. Let me start with a story, just to set up the stage, as I mentioned. And this is totally a hypothetical story. Alex is also a hypothetical character here. But as they say, once upon a time, in a small town, there lived a brilliant young engineer named Alex. Alex, he had a lot of knowledge about how the things work. He was also obsessed and passionate about solving the problems. And he used to work in a makeshift workshop in the backyard of his house. He also used to hang out with like-minded people when he had a bit of time. He was working day and night in his workshop to solve some very challenging problems. And while hanging out with his friends, he would usually discuss the progress he's making in all those problem-solving avenues. So one night, he realized he came up with a groundbreaking discovery, which can solve a very big challenge. And he just mentioned to some of his friends. And later on, one of the friends, I wouldn't consider that person as a friend if he did what I'm going to mention. So that person actually broke into his workshop. He stole all the initial designs, documents, and also stole one of the prototypes. What he did, he registered all the intellectual property rights he could, and he started taking advantage. He started marketing that product as his own product, and he also started a litigation against Alex, stopping him from working any further on that innovation. This was very heartbreaking for Alex, but Alex did not lose hope. Obviously, he would come back, but I will stop the story at this point. Now, this Alex could be you, it could be me, everyone who is working in engineering field, but not much aware about intellectual property rights. All right, so with that in mind, let's try to understand the basics behind intellectual property. So the basic concept is that if a person is putting some additional efforts, they must get some sort of reward. So these intellectual property rights, they usually grant some legal rights to exploit the innovation or that innovative development that person has come up with using their own intellect, using their own talent, using their own creativity. They should be able to exploit that innovation. So this sort of grant of legal rights encouraging innovation and creativity. And with more innovation and more creativity, society prosper and progress. There are more solution of problems available, more challenges can be overcome by intellectual people, and that's how society can make progress. Now, just imagine if there was no reward, who would like to innovate? Who would like to invest all that much amount of efforts, time, etc., working towards solving some sort of problem if they are not going to earn anything out of that? So that is the basic concept behind any intellectual property in any corner of this world. So let's start with a little bit of interaction. I would like to interact more. So just let's start defining intellectual property. What do you think? What is intellectual property? Yep, so I have some responses here. Knowledge, copyright, rights to ownership of ideas, thoughts, and design, collective terms for patents, design rights, copyrights, trademark, and confidential information. Product ownership is exclusive to a person. Yeah, these are some of the right ideas in terms of defining intellectual property. Now, World Intellectual Property Organization has defined intellectual property as creation of the mind, such as inventions, literary and artistic works, designs and symbols, names and images, which are used in commerce. So with that basic definition in mind, we will move. There are some essential features of intellectual property. So just like any other property, intellectual property has to have some basic features which can help us identify that this is our intellectual property. So the first feature is called documentation. Any intellectual property will have some form of documentation associated with that particular intellectual property. Some sort of letter, some sort of grant letter, something like that. Some documentation has to be there, always there. Secondly, we have intellectual property being issued by legally authorized government agency. So some countries have intellectual property offices, some countries have patent offices, some countries have copyright offices, some of them have everything in just one office sitting together, but there has to be some legally authorized government agency. Then comes description. So documentation of this intellectual property. So this little bit ties back with our first part, which is documentation. So description is always provided under documentation. The documentation will also list about the ownership. Who is the rightful owner of that particular intellectual property? It will also mention the time duration. For how long is that sort of legal protection valid? How long will it last? So that is there. Also, intellectual properties, they come with some sort of fees, but there are some exceptions as well. I will touch base on that later on. But many a time, some fees is associated. And more importantly, these properties, as the name suggests, they are properties and they have some commercial value. All right, so let's think about intellectual property in our day-to-day life. What can you think when I say intellectual property in day-to-day life? Just feel free to share various examples through the chat box. Thank you very much, everyone. Just keep them coming. I can see some really great examples of intellectual property in day-to-day life. So a piece of song, particular aspect of packaging, design works, code, software, particular brand name. So many things. I have a few simple examples over here. So the clothes you are wearing right now may have some sort of intellectual property associated with them, or maybe the shoes that you're wearing, car you're going to drive, the phone you are using, someone's reading a book, maybe it has some sort of intellectual property associated with that. You go out for a walk, you come across some really great variety of roses, they may also have some intellectual property associated with that. And apart from that, lot of great examples shared in the chat box in terms of technical aspects of those intellectual properties. So, great, thank you very much, everyone. All right, moving on to building this a bit further. Let's try to discuss why intellectual property is important in emerging technology. Why industries, companies, they need to put a lot of attention and resources and efforts in protecting their intellectual property. Why it's so important? Yep, again, thank you very much, everyone. Some really great points and ideas being shared. So thank you. And it's really good to see a lot of you have a lot of understanding in terms of intellectual property. I will put it slightly differently. So in order to explain you the importance of intellectual property, I will show you this graph. Now, let me just give a bit more context. This is the graph of tangible versus intangible assets of 500 S&P 500 companies for various years. So this great part that you're looking at, that shows how much amount of tangible assets were involved at that given time. And this blue part shows how much ratio or proportion the intangible assets were made up of. Now let's just quickly have a look at what does it mean when it says tangible and intangible assets. Tangible assets, we have buildings, we have cash, we have the particular land, this sort of physical aspects of property that will all fall under tangible assets. On the other hand, we have intangible assets. So intangible assets, they cover patents, they cover brand value, they also cover customer data, goodwill that the company has gained in the market, and it also covers software. So if you just check it out, during 1975, 17% of total assets were made up of intangible assets. That includes patents and intellectual properties. As you move on to check 1985, you can see that that increased to 32%. 1995, this particular time saw a huge change in terms of holdings of intangible assets. Intangible assets became more than 50%. So those S&P 500 companies has 68% of assets in the form of intangible assets. And then it kept increasing. 2005, you can see 80%, 2015, 84, and 2020, you can see that a lot of assets, most of the assets are in the form of intangible assets. And that's why it's super important to protect those intellectual properties, which are part of intangible assets. So I hope that makes it clear the importance and why it's really crucial to protect the intellectual property. All right, coming back to ourselves, engineers, how knowledge of intellectual property can help us, engineers, as individuals. All right. Thank you, everyone, those who have already shared and those who are still sharing their ideas on how this knowledge can help engineers. Here are some of the points that I have listed. So we'll just quickly go through them. The first point is protection of our innovation. So engineers usually are at the forefront of innovation and technological advancements. We develop new inventions, designs, and solutions which can have significant economic and societal impact. So knowledge about intellectual property will ensure that we can protect our creations, and we can also prevent unauthorized use or exploitation by others or other competitors. And this can be done by obtaining all relevant intellectual property rights. Second thing is legal compliance. Now, intellectual property laws, they exist to provide legal frameworks, and that framework will help protect the rights of creators and innovators. So we as engineers need to be aware about those laws, regulations, and framework to ensure that work that we do is in compliance with all those frameworks. So understanding intellectual property rights will help us avoid unintentional infringement on others' intellectual properties, which can again lead to legal disputes and expensive financial liabilities, damage to protect our professional reputation, etc. The third point is encouraging innovation and investment. So intellectual property protection fosters climate of innovation, and it will also encourage investment in research and development. So when engineers know that our ideas and inventions are safeguarded, then we are more likely to share and commercialize these innovations. And this in turn will promote a vibrant culture of creativity. It will drive technological progress, and it will obviously attract investment from companies. Collaboration. So that brings us to the fourth point, which is collaboration and licensing. So intellectual property can be leveraged to facilitate collaboration and technology transfer between different entities. Engineers who understand that intellectual property is better, they can engage in those licensing agreements better, and they can also grant permissions to others for using their invention in exchange of royalties or some sort of other benefits. But at least we know the value of our invention. The next point is business and entrepreneurship. So engineers, they played critical roles in entrepreneurial venues and ventures, startups, technology-based businesses, etc. And this knowledge about intellectual property, it will become really essential when developing business strategies, creating value propositions, and also establishing market positions. This knowledge will also enable engineers to identify competitive advantages, build strong patent portfolios, and negotiate licensing agreements. Last but not the least is ethical consideration. So intellectual property is fundamentally tied to ethical consideration as well. And we need to recognize others' work while building up on someone else's work. So we will again come back to this towards the end. And that brings me to perhaps the last question, I promise. I've been asking a lot of questions, but I like to keep it interactive. So that's why I've been asking you a lot of questions. What are various types of intellectual properties? I have deliberately been not mentioning the names, but still you guys seem to have a lot of idea about the various types, and that's why I'm asking you this question. Mostly I should get the right answers, and then we'll move on to dig deeper about each of this. All right, so yeah, I can see a lot of main intellectual property types being mentioned here in the chat box. So we will start with patents. Then we have design rights, registered trademarks, copyrights. We will consider this for a bit more in detail. We'll touch base on plant breeders' rights and very briefly discuss confidential information and or trade secrets. So these are some of the main intellectual property types that we need to be aware of being an engineer. Let's start with patents. So patents, they protect device, substance, method, or process which is new, inventive, and useful. Now cost, it costs around $110. This is the minimum cost to register your provisional patent application. The cost can go up to several $1,000s for the full protection, but I'm just mentioning the minimum cost over here. How long does it take? Once you apply for your patent, it can take somewhere between 6 months to several years to get registered, depending upon the process, depending upon the queue. At the moment, patent office here in Australia is quite busy, so many applications being filed every single day. How long does the patent protection last? So it lasts up to 20 years for any standard patents and 25 years for any pharmaceutical related patents, provided the renewal fees are paid every year, which needs to be paid annually, of course. Examples of some patents. So technology behind Google Maps could be one such patent example. This cochlear implant it's an example of a device, obviously, but that is also patent protected. And an example of a substance which is patent protected would be the polymer currency notes, which we use here in Australia. They are also patent protected. Now, let's discuss about what can be patented. So, as I mentioned, any device, substance, method, or process can be protected. But again, there are a few other aspects that we need to consider. So, in order to be granted a patent, we need to make sure that the invention is new. It must be novel. It should not be disclosed to anyone before the application. Now, this is really, really important when it comes to disclosing to anyone. Unless you have filed your patent application, you shouldn't be disclosing. Or if you need to discuss, you have some other options like a non-disclosure agreement or something like that. The second aspect is your invention should be useful. So it can be made or it should be used in the industry. The invention should be inventive, so it should be different enough to what already exists. And it should not be something which comes naturally to a person who is working in that particular field for quite some time. And last bit is a suitable subject matter, which is known as manner of manufacture. Now, this is applied to each and every patent application on a case-by-case basis. What are the advantages of getting a patent? So when you get a patent, you have exclusive commercial rights to exploit your invention. That can give you monopoly in the market. You also have freedom to license someone else to manufacture that invention on the agreed terms, and to license someone else to manufacture that invention on the agreed terms. And it also gives you the right to take legal action that stops others from manufacturing, using, and or selling your invention in Australia without your permission. So these are some of the main advantages of registering a patent. Let me walk you through this entire patenting process. So if you are not thinking provisional application, then mostly you will start with this standard patent application. So the moment you, or the day on which you actually apply or you submit standard patent application, that will set your priority date. We'll come back to priority date a little bit late, but this is an important milestone in patents. So priority date is established on the day when you submit your patent application, along with specifications and claims. So your application, once you submit, it will be published soon. Now, while you are submitting this, you can carry out some preliminary search and you can get some expert opinion, but then patent office will publish your application. And any infringement can be started or backdated to this particular date. You cannot start infringement at this point, but later on, once the patent is granted, you can backdate your infringement to this date. Now, next step is examination. So this was the filing stage. Next is examination stage. Examination stage, you can request your examination at the time of filing your patent. So it can be done along with your patent application at this stage itself. If you need a bit more time to prepare, and also it incurs a separate fee. So if you need a bit more time, you can have that time, but you need to request examination as a patent applicant. So once you request your examination, examination is being carried out by the patent office, and there are two possible outcomes. If everything's all good, your application is accepted. Or if there are some issues, they will issue a report. Now, sometimes report will ask you to provide some responses. So you can file the responses, and if acceptable, the application will get accepted. Sometimes application will be rejected based on major issues over here. So if that is the case, then you can appeal in the court. That decision can be appealed. But yep, let's say our application has been accepted. So once application has been accepted, they allow a certain period of time. So this is your acceptance or grant stage, and they allow the member of public a certain period of time to act up. If anyone has any opposition, any member of parliament, any member of public has any opposition, they can start acting at this stage once application has been opened, accepted and opened. If no such opposition filed within that time period, the patent is granted. Once the patent is granted, infringement proceedings can be started and it can be backdated. So during this period of time, if any infringement has occurred, you can start proceedings against those infringements. And then annual renewal fee to be paid, and then finally it will expire after the set duration of time. So that is the usual patenting process. Now, there are a couple more things. One is prior art base and priority date. As I mentioned, priority date is a very important milestone in your patent application. So novelty and inventive or innovative step, it require a comparison with specified documents and acts throughout the world. So this base of comparison is usually referred to as prior art base. So something similar is already applied for that will make a prior art base for your given application. Now, priority date, I already mentioned, but I'll repeat here again that it's a date of claim or the date of filing your specifications of your patent. So the moment when your invention claims were first disclosed, that is the priority date for your patent application. So any patent application with earlier filing date will become prior art to the later filed patent application. Let's say applicant A has filed a patent application on 1st January. And a similar application has been filed by applicant B on 1st of March. So for applicant B, application A will become prior art, which means something similar is already been applied for. And applicant A has greater chances of being granted that patent. So that's why priority date is really important. One more aspect is provisional application, and it is available in many other countries as well, not just in Australia. So if you don't have time to prepare the full patent specification, claims and documentation, or if you are still in a bit of dilemma whether you should proceed and get the patent protection or not, this is one of the ways to go forward. So provisional application, it's optional, inexpensive way of signaling that you may file a standard patent later on. So it's more like a placeholder. It doesn't give you any protection. But if you decide to file on a standard patent, the date on which you have filed your provisional application becomes your priority date. So that is one main advantage there. So by filing this provisional application first, you will have around 12 months time to prepare and decide. You will have additional time to research and work on your invention. And that will also establish your priority date in case if you move forward and file a standard patent. Keep in mind though that it doesn't provide any level of protection to your invention, and it can result in your invention details being published. Next important aspect is patent search. One needs to do their own search before even preparing to apply for. Patent office is obviously going to search about any prior art base, but as an applicant, it is also our responsibility that we should also search. So why should we search? If patent office is going to search about that, why should we search beforehand? There are a couple of reasons here. We need to ensure that similar invention or product hasn't already been patented by someone else. We also need to know that similar product or invention hasn't had any details of what it is and how it works published in where. If that knowledge is published, we cannot apply that. And we can also use this search to see how similar patent applicants have written their specifications. So that will bring us to the documentation, I guess. Yeah. So here we have patent documents. What would we need to submit as a part of our patent application? So the first and important thing is ownership and inventor details, postal address, etc. Contact details of agents if we have any patent attorneys or agents working on our behalf. This is the important part of documentation, prepared specifications. And of course the payment details. So let's expand a bit further on these specifications. So patent specification, it must include the description of our invention, the statement of claims. I'll come back to this because it's again really important. It must include the summary abstract, and it must include drawings if applicable. Most of the times drawings will be needed there to support our claims. Now claims are really important part of our patent specification. The patent application claims, they will set forth in words the content and scope of property rights the inventor is attempting to secure through the patent grant. So basically myths and bounds of your legal protection is set forth by the claims. Each claim will define a separate and distinct property right, and claims of patent will define the subject matter of invention, and it will serve as myths and bounds. Claims also serve to provide notice to the public of the precise area of technology that is fenced in by this exclusive rights of our own patent grant. So our competitors and would-be infringers would know where not to tread. So these are the parts of our patent specification. And that brings us to the infringement. So how is patent infringement determined? Let's assume that we have prepared all the documentation, we have applied our patent. After all that lengthy procedure, patent has been granted, and we come across infringement. Or we are wondering that, okay, so-and-so product which is available in market from a competitor, whether it is infringing our patent or not. So how do we know that? Very simple thing. Patent infringement is determined by comparing imitators' product or process to the claims of our own patent. And that's why I said claims are really important. They set up the myths and bounds of the legal boundary that will protect our patent. Each claim would be in the form of single sentence, and you can consider that as a feature. Each claim will give one feature of your product or invention. And in order to infringe a patent claim, each and every feature of the claim must be taken. This is benchmark case, Doric case. You can search it up on Google, but in Doric case, the court established the guideline that as a fundamental rule, the test of infringement is determined by construction of the claim. There will be no infringement unless alleged infringer has taken all the essential features of the claim. So say, for example, you have 16 different claims in your patent application, the infringer has taken only 12 claims out of 16 in their infringing product, then it's not the case of infringement. In order to have a solid sound case of infringement, the infringing product, you should be at least be able to establish that infringing product is taking all 16 out of 16 claims from your patent. That infringing product is taking all 16 out of 16 claims from your patent application. So that is patent infringement. And so far, whatever we have discussed, it's just applicable within Australia or within a given country. If you are thinking about getting international protection, I'll just quickly give you a couple of ideas here. The international protection can be secured through Paris Convention, which is known as convention application. Now, that is one of the two ways. I'll expand a bit further on each. And second is known as Patent Cooperation Treaty, PCT application. So one of the two, you need to decide which one is more suitable for you. Now, Paris Convention, there are quite a lot of member states who have signed Paris Convention. And if you are residing in one of the member states who is part of Paris Convention, you can apply in any other member state who is part of Paris Convention. Paris Convention, to be honest, it's a bigger umbrella and it doesn't only cover patents, it also covers other intellectual property rights. But there are two significant aspects of Paris Convention. The first one being national treatment. So if I am a resident of country A, who is part of Paris Convention, I decide to apply in country B, who is also part of Paris Convention. Country B has to treat my application as any other application from their own resident. They cannot have a separate criteria or separate guideline for treating international application. So each and every application in country B coming from Paris Convention pathway must be treated in that same way as they will treat any other application from their residents. Second important aspect under Paris Convention is called right of priority. Now, this is also an important aspect because say I have applied in country A, my own country, on 1st of January 2023. And then a couple of months later, let's say 1st of March 2023, I decide to apply in country B. What would be my date of priority in country B or priority date in country B? Although I'm applying in country B on 1st March, my priority date is still maintained. Whatever was the priority date for my very first application, that still remains applicable in rest of the member states. Not just country B. If I apply in 2, 3, 4 different member states of Paris Convention, they all have to maintain the priority date from very first application. So that is right of priority. No, Richard, unfortunately, we have to decide whether we would like to go through Paris Convention or PCT pathway. We cannot use both of them. And again, saying that PCT is slightly more expensive as well, but it will give you a bit more time. PCT will give you, from memory, around 30 months time and to prepare and apply. So the second part is PCT. I'll just quickly touch base on this Patent Cooperation Treaty. It makes it possible to seek patent protection in all the member states. It's only for patents. And yeah, you cannot register any other intellectual property using PCT. Now, initially, international search is carried out and international search report is prepared. So that will give you a lot more guideline. And once that is done, it enters the national phase. So when your patent enters the national phase, each and every country will treat your patent application in their as per their local legal framework. And you have to prepare your documents and works as per their guidelines, local guidelines. All right, now a couple of points before applying we need to think about. So the first and the most important thing is what a patent is and what can be patented. Patent actually protects the process or how exactly a particular invention works. It doesn't protect how exactly a particular invention looks. So if you are trying to protect the looks, perhaps patent is not for you. This is just an example. Keep your invention a secret. Don't just publicly announce it, don't present it to the conferences, or don't even discuss it with irrelevant parties unless they have signed a non-disclosure agreement. Decide if your idea is worth pursuing now. Sometimes market is not ready for the new technologies. It's worth waiting a little bit more time. Sometimes you need a bit more time preparing your documentation. So you need to decide when exactly you'd like to apply for. Choose if you are going to file a standard patent just for the local production, or international, or even provisional application is also an option here. And you also need to understand that patents are costly. They incur a lot of fees, so we need to keep that in mind. All right, so that was about patents. Now moving on to design rights. So design rights, they protect overall visual appearance of new and distinctive products. It doesn't protect how the product works. I will go a bit more into the detail what it doesn't protect. So just quick look, it will cost around $250. I'm just mentioning minimum cost. It can go high as well. Duration, it takes about 2 months to register and 4 months to certify approximately. And how long does it last? So design rights, they last up to 10 years. You need to renew them at 5 years benchmark. So here are some of the examples. This particular dress, the way it looks, is protected under design rights. This Audi car model, it's the shape. I'm not talking about various technologies that go behind that particular car, but overall shape and look of the car is protected under design rights. How this particular sofa looks aesthetically is also protected under design rights. What are the advantages? So design rights, if you register and certify your design rights, it will give you the exclusive right to use your design within Australia. It will also give you exclusive right to authorize other people to use your design in Australia. Design right, it will grow in value, and you can also even sell it, or you can license it within the country. You have the ability to apply for the same design right overseas, given that you're doing it within 6 months of your first Australian application. And it will also give the right to take legal action against someone who is using your design without your permission. So these are your advantages of registering design rights. What is protected under design rights? So design rights, they aim to protect visual appearance of a whole product, which is physical and tangible form, which is manufactured or handmade, and which is produced on a commercial scale. Any quantity under 50 is not considered as commercial scale. So up to this number, it is still prototypes. But the moment your manufactured quantity exceeds that amount, that is your commercial scale. And then you have to apply for design rights if you are looking for protection. All right, expanding a bit more on what is not protected. So designs with no physical form, just a concept, process, or computer graphics. Let's say you have created really nice computer graphic, that is not protected. But if you apply that graphic to your laptop sleeve, then it becomes your physical form, and then it is protected under design rights. Brand name or logo, which is developed for a particular product, is not protected under design rights. We have to look for some other intellectual property for that. How exactly your product works is not protected under design rights. What materials you are using in your product, again, it's not part of your design rights. You can look at patents for this too. Size of the product and partial design features of the product are also not protected under design rights. Now, things to consider before you apply for design rights. We need to understand what will be protected, and we also need to understand that it is the right intellectual property for what we need. We need to keep the design a secret as well. If you disclose it to other people, it becomes public knowledge, and then you cannot ask for any protection. You need to search for similar design. If something similar is already existing, just like patents, you cannot get that protection. You need to know how a design right can impact other IP rights. I will, in the next slide, discuss this a bit more in detail, and decide how many designs you want to protect. Sometimes in the same application, you can apply for more than one designs. All right, so quickly looking at design rights and copyrights. Copyrights, I will cover them in the next slide, I think. But copyrights are automatic. The moment you start creating any copyright-worthy material, it's protected under copyright. So say, for example, you are developing a new product and you have created some concept sketches, drawings. These are all protected under your copyright. But if you decide that you are going to register and certify your design rights, the moment your design rights are granted, copyrights will not protect any other material which is already protected under design rights. So once the design is registered under Designs Act, it will lose its copyright protection. So say, for example, if someone makes a replica of the design, not on a commercial scale, just one replica of a design or just the computer graphics of the design, it's not an infringement. If someone reproduce underlying artistic work as part of manufacturing process, it's not an infringement. And reproduce underlying artistic works in promoting and advertising replica is also not infringement. If copyright was there, then of course this will become copyright infringement, but it's not a design right infringement anymore. And that brings us to trademarks. Sorry, I wasn't sure. Copyright will come after this. So trademark will protect companies' unique brand, products, or services. It will cost around $250 for registration. Registration takes around 7 months minimum, and trademarks lasts up to 10 years before renewal. What are various examples of trademarks? So your logo, this Nike swoosh, is an example of a trademark. Even there exist color trademarks. So this specific purple color that Cadbury has been using is also a trademark. And this specific shape of Coca-Cola bottle is also a trademark. So trademark is not just a logo, it is more than that. And we'll go a bit more into detail what exactly sits under trademark. So registering your trademark is sort of a business asset. The more successful the business becomes, more valuable trademark becomes. It gives you legal right to place this registered symbol and right to place this registered symbol, and it will deter other people from using your trademark in their business. It will also give you exclusive right to use that trademark in Australia, ability to legally deter others, and ability to sell that, license that for others to use it. Now, what is protected? As I mentioned, it will protect your product or service in the market, and it will also help customers differentiate or distinguish your product from other businesses' product or competitors' product. We will expand this a bit more. So, types of trademarks. What is protected? Any of this or any combination of this is part of trademarks. So word or phrase trademark is there. Say it will protect your numbers, letters, words, or phrase. L'Oreal's because I'm worth it is a trademark. We have fancy font trademark, so it will protect the words or phrases in very specific font style. Say the cursive font that they use for Ford is fancy font trademark. Non-English trademark, so non-English words written in Roman or non-Roman characters. Gongcha, Volkswagen. Then we have logo or figurative trademark, which we are more used to consider as trademark. So it will protect the logo or a picture, as we have seen Nike's swoosh logo. Then we have series trademark. So same company involved in more than one products can have series trademarks. So Telstra Standard, Telstra Deluxe. These are series trademarks. Color trademark, as we have seen in the example, particular combination of colors, Cadbury's purple shade. Then we have shape trademark as well. So 3D shape of a product can be protected under this, and Coca-Cola's original glass bottle or Toblerone chocolate, if you know, the triangular shape is also protected under shape trademark. Sound trademark also exists, so it will protect a distinguishing auditory piece. Say MGM Lion is that roar is protected under sound trademark. We have scent trademark as well, so a distinct smell associated with a certain product. Eucalyptus radiata scent, which is applied to golf tees, is protected under scent trademark. And then we have movement trademark. So that Toyota Jump, any animation or movement associated with a certain product, Microsoft or Toyota Jump, these are all movement trademarks. Just a quick detail information about what symbol to be used. So we have two symbols. We have this TM and we have this R symbol. Now this TM symbol is a trademark symbol, and it can be used for both registered as well as unregistered trademarks. So trademarks could be something that you have been using since years and you have never registered it. So for that, you can use this TM. Even if you get your trademark registered with IP office, you can still put TM on your trademark. Now this particular symbol, R in a circle, it is the symbol that says that your trademark has been registered with the IP office. So this particular one can only be used if your trademark has been registered and approved. So then only you can start putting this registered trademarks. But TM can be used by anyone. And trademark doesn't have to be a secret. You can be using it for quite some time, and then later on, if you realize that you need to register it, you can go on and register your trademark. Next one is copyrights. So copyrights, as the name suggests, that protect someone else from copying your original idea or information which is being communicated. So original forms or way an idea or information is expressed. Just keep in the mind, it doesn't protect the idea itself, it protects the expression of the idea. So that will include any written material, visual images, music, or any moving images. These are all part of your copyright protected material. This is free. So the moment you generate any copyright worthy material, copyright is automatically applied to it. You don't have to get it registered somewhere. So it is free, it is automatic, and it exists the moment material form is created. So I think I have touched based on all of them. And copyrights, I will say they last forever. Not exactly forever, but they last for a very long time. Life of creator plus 70 years, just as a guideline. What is protected under copyright? So any piece of writing, any piece of music, visual images, broadcasts, any sound recordings, moving images, or any computer programs would be protected under copyrights here in Australia. What are the rights of copyright owners? So copyright owners, they have some economic rights, and then there are some non-economic rights as well. Well, let's first consider the economic rights. So the copyrights gives the copyright owner the right to reproduce the material in a material form. If you've written a book, it's protected by copyright. You can reproduce that same book, reprint that same book in the material form. You have right to publish the material. So you can publish that book, make it available to the public. If you have written a song and you have sung that song, you can also make it public, copyright protected. No one else can reproduce that material without your permission. You have right to publicly perform that material and right to communicate the material to the public. So it could be in the form of making that material available online, or making that material in the form of a broadcast, or transmit that material in some form. So these are some economic rights, and then there are some non-economic rights. So that will cover the right to attribution of authorship and performance of one's material. Someone else is doing it with your permission. You have that right to get that attribution of authorship in your name. Rights against false attribution of authorship and performance, and rights of integrity of authorship and performance. So these are some non-economic rights. How long? So as I mentioned, copyrights, they last for a very long time. So 70 years after the death of the author. So it lasts for the whole life of the author plus 70 years after the death. 70 years after being made public for sound recordings and films. And if it's a broadcast for television and radio broadcast, it will last for 50 years after being broadcast for the first time. Okay, when it is infringed. So copyright is infringed if a person does one of the exclusive acts which are reserved to the copyright owner without permission from that copyright owner. Even if someone takes part of the copyright item, it will become infringement if a substantial part has been taken. Now, that substantial part is a bit of a gray area, and yeah, at times it's hard to prove in the court whether substantial part is taken. All right, I'm not looking at the chat box at the moment. Apologies everyone if I have not answered your questions. I'm not looking at the chat box. I'm just trying to cover the content first, and I will try to go through some of the questions, if not all, towards the end, so that at least we can finish the content. Thank you very much, Barry. I appreciate that. All right, are there any exceptions to copyright infringement? So yes, there are some exceptions. If copyright material is being used for research or study, or criticism or review, if the material is being used for reporting of news, giving professional advice by a lawyer, if it's used in parody or satire, and making accessible format copies by or on behalf of a person with a disability. Say you're writing a book in Braille for blind people to read, then it's exception. It's not an infringement. All right, moving on. Few examples. Now, we have been talking a lot about artistic materials, but what is relevant to us, engineers? So, engineering drawings, engineering or technical photographs, flow diagrams that we create, concept sketches. In the product development initial stages, we will create a lot of concept sketches. Even computer programs, user manuals that we write for a given product, and if we are preparing a planning application, they are all copyright protected material for engineering field. So that was about copyrights. Moving on to the plant breeders' right. I will just very quickly touch base on this. So if you have come up with a new variety of plant, you can get protection with plant breeders' rights or PBR. It protects new varieties of plants, fungi, and algae. Costs around $2,300 on average, plus there might be some other external fees. It takes typically 2.5 years to get your plants registered, and it will last up to 20 to 25 years depending upon your plant type. Some examples, we have this example of a barley plant, we have this specific apple plant, and we have this specific flower plant, which are protected under PBR. All right, moving on to the next bit, and I think it's the last bit if I'm not mistaken, and this is confidential information or trade secret. So what are they? Now, at times we usually refer to them as the neglected cousins of other intellectual property rights because there are not very sound legal framework around this confidential information and trade secrets. They are easy to infringe due to that fact that there is no sound legal framework. But let's just go a bit more into detail. Confidential information, as the name suggests, it's any information that you regard as confidential. You don't want to disclose it to each and every person you come across, and you would like to safeguard that. Trade secrets and know-hows, they are the subsets of confidential information. Of course, they will sit under confidential information. You don't want everyone to know the trade secrets or know-hows. Now, confidential information, it could be in the form of financial records, marketing plans, customer lists, etc. Trade secrets and know-how, they would have some typical technical information. How to protect confidential information. So if you are seeking some sort of protection for confidential information, it needs to be treated as confidential. We need to ensure that we are treating it as confidential. So for example, we should be marking the paperwork as confidential, keeping the information in a secure place when it's not actively being used. It must be shared only with those on a need-to-know basis, and all copies are accounted for. We are keeping a track record of where each and every copy is going, how many copies are being created, etc. We need to have clear, well-drafted confidentiality obligations in employment agreements. We need to have clear, well-drafted confidentiality obligations in employment agreements. So if we are going to employ someone, we need to have that confidentiality agreement set forth in their employment contracts. If we are going to work with consultants and contractors, then also whatever agreements we are going to prepare, the same thing should be embedded in that as well. How long would this sort of protection last? So as long as we keep it confidential, it will last. The moment we make it as public knowledge, or the moment it becomes public knowledge, the protection is gone. All right. So summarizing all different intellectual property rights. I will use this example. Let's say you are in a coffee business and you came up with a very new technology which you have embedded in your coffee machine so that it can extract a lot more from your daily roast. So that new technology or how that coffee machine works is protected under patents. You have also designed a very specific coffee mug to sell your coffee. So the way your mug looks is protected under designs. You might be using this sort of logo on your coffee machine, on your coffee cup, that will be protected under trademarks. You have developed a very specific variety of coffee plants. So this will be protected under plant breeders' rights. Now you have developed some user manuals, you developed some advertisement materials for your coffee business, and that will be protected under copyrights. You have come up with a very secret formula of a coffee blend you're going to use in your business. So that will fall under trade secrets. So I think this will give you a bigger picture of where each and every intellectual property right sits and what it protects. Now, just moving on to the last bit, that is ethics considerations in intellectual property. Now, as engineers, we are very responsible professionals, and in each and every country, the code of ethics has been clearly outlined that we need to follow as engineers. So this is the code of ethics from Engineers Australia, and I have made whatever is relevant to ethical practice in intellectual property, I made it all bold. So these are some of the aspects we need to think about. As I have been mentioning, intellectual property is fundamentally tied to ethical considerations. Honesty is there, integrity is there, and respecting the rights of others is also part of intellectual property. So as engineers, we have professional responsibility to uphold those ethical standards, and we also need to act with integrity in our profession. So what will it include? It will include recognizing and respecting the intellectual property rights of others, avoiding plagiarism, and ensuring that our own work is original and it is also properly attributed. Here are some main points. So we need to respect for other people's intellectual property rights. Just some summarization of those ethical considerations. So it will also include that we maintain integrity in research and development, we properly disclose the invention while we are applying for patents or any other intellectual property protection. We also need to foster responsible collaboration. We need to avoid misappropriation. Continuously, we need to educate ourselves about best practices and intellectual property laws, and if there are any changes taking place. So these are all part of our ethical considerations. Going a bit more over the time specified. Barry, I hope that's all right. We'll just quickly cover last couple of slides.
That's still fine, Doctor.
Thank you so much. So we'll just quickly walk you through some guidelines on patents. So just keep in mind that each and every piece you come across, think that there has to be some sort of intellectual property involved in that. It could be some everyday drawing, diagram, prototype, it could be anything. It will all have some intellectual property right attached to that particular creation. There are multiple aspects of intellectual property. We have discussed, I think, 5 or 6 different regimes, but the one that we need to know the most is patents. We need to be aware about patents. And also, instead of assuming if we are doing something new, many a times we will underplay it. We will assume that, oh, it's something everyone would know. Don't think like that. Think if it's new, innovative, and whether you can have some sort of protection for your idea or for your work. And also keep in mind, while building upon someone else's work, we need to be mindful of their intellectual property rights and how not to infringe someone else's intellectual property rights. Some guidelines on public disclosure. So as engineers, we are always under pressure, or sometimes we are put on the spot to present at technical events, webinars in front of reporters, what's going on in our field, what we are working on in our particular company. So we need to be very careful on what we disclose publicly about the new developments especially before a patent application has been filed. Once it is filed, it becomes public. Patent office opens it up for the public, and in return we get that exploitation right. And we also need to be careful not to be over enthusiastic or premature in presenting data, even if our venture capital is at stake. And copyrights. So copyrights, they subsist in tangible things that are product of someone's skill and labor. Now, artistic work that we come across as engineers involve engineering drawings, photographs, flow diagrams, as we have discussed. We also come across some literary works like text or user manuals where copyrights do exist. And as engineers, we do come across computer programs. Many a times we just identify machine, object, and source code as the only computer programs. But CNC machine codes are also part of computer programs and copyright protected. So copyright are something for which we need to be really careful about. They subsist automatically. They don't need to be registered. They last for a very long time. And copyrighted work, it could be a 2D work or it could be a 3D work as well. Actual product created based on that drawing is also copyright protected. And adapting is also prohibited. If we try to tweak the things here and there a bit, and then if we reproduce it, that is also copyright infringement. All right, so that brings me to the last bit, and that is IP resources. As I mentioned, the most of the information that I've covered is coming from IP Australia. That is the government agency here that works towards intellectual property rights for patents. It doesn't work for copyright. Rest of the things, they sit with them. So if you are not in Australia and if you are looking for a bit more information, this is your go-to resource. World Intellectual Property Organization, a lot of member states are there. And yes, they have the list of all the member states. And if you just click your particular country, if that's part of the members, part of this World Intellectual Property Organization, it will take you to your own countries or that particular country's intellectual property office website. So it's super easy. If you are here in Australia, the two main resources for you to go is IP Australia website. That's the government agency that looks after anything, but not everything, but mainly the patents, trademarks, plant breeders' rights, and design rights. And if you're looking for copyrights, it is Attorney General's office. So these are the two main resources for local Australian residents, and this is the main resource for those who are not in Australia. And that's about it. Thank you very much, everyone. I'll just quickly go through the chat box while Barry is just addressing everyone.
Thanks, Dr. Arti. Yeah, just before we go into Q&A, so you can just see our upcoming programs here. So just to read more, you can always just go on our website, EIT, and then under course schedule, you should be able to see all our programs that are currently running. Okay, so we don't actually have an upcoming webinar at the moment, but you can always just go and check all our previous webinars and our website. And then we also have a couple of IDC conferences that are upcoming. So you can also just go under events to read more about the upcoming sessions or conferences. All right. So those who have been actually asking me about the certificates of attendance, so you can actually just scan the QR code now, and then you should be able to complete a short survey form, and then that should lead you to have to get your attendance of a certificate of attendance, which should be sent to you in about 1 to 2 days business working days. And then I will also just share the link for those who are not able to scan the QR code. So if you can just follow that link, you should be able to have access to the form. All right, so I'll just now wait to just for any questions that Arti wants to address.
Thank you very much, Barry. Yes, I'll just go through a couple of questions. Patent, you can apply for each and every patent in each and every country that you are seeking protection in. So each and every country has different requirements, and obviously you have to follow those requirements. PCT or convention application will give you a bit of a start, and it will do a bit of research for you, and it will prepare some background information for you to decide whether you would like to proceed with your application. Saying that, convention application is good if you are seeking protection in 2 or 3 or 4 or 5 handful of countries, but if you are looking at getting protection in more countries, then PCT is your way to go. It will be cheaper for more amount of countries if you're planning to apply. So that was one of the questions. Next one, when is it practical to pursue intellectual property protection for your startup? As early as you can, because you will be working with a lot of people, you will be discussing your ideas, invention with other people. You don't want to make it public. So, and you don't want to keep everyone signing non-disclosure agreement every now and then when you want to discuss something new. So the earlier is better, I would say. Copyright and cover songs, and who does the copyright belong? Now, that will depend on your employment agreement. If you're working as a contractor, then you again need to see your contract agreement. If it says, most of the times contractors, they used to keep the intellectual property rights, but if you are an employee, many a times, this is just the general norm, many a times your employer will keep the intellectual property that you create as an employee. But it could be different in your contract. So check your contract, that's the best thing or advice I can give. AI created material is a bit of a gray area. Some countries are granting protection, some countries are not granting protection. So it is very country specific, and it's pretty new at the moment as well. So there are no very clear set rules, but most of the times copyright here, I think there was an interesting case where court wanted to decide whether copyright belongs to, whether copyright subsists or not. And then they based their final outcome on whether they could figure out who was the author of that material. So yes, here in Australia, there has to be a human author to get that copyright protection. Copyright lasts for the life of author plus 70 years after the death of the author. And that is the case here in Australia. But it is more or less the same. Copyright protection is very lengthy all over the world. But yes, country to country, it might be slightly different. So encouraging everyone to check that. And with that, I think I have answered most of the questions.
Okay. Yeah, and then just to also add, for those who have been asking about the slides and together with the recording, we should be emailing you this into business days, so you should check on your also spam or junk folder for that. And then in that case, that's it from us. Thank you, Arti, and thanks for everyone for joining today.
Thank you very much, Barry, and thank you very much, everyone.